All right.
Then we'll go ahead and get started. Okay. Hope everybody's doing well. If you have any questions, just take yourself off of mute since chat is filled with names and not messages today. So just take yourself off of mute. The things that we're going to do is review again the contract changes about the new and public improvement district and some updates on that, and then the HOA laws changes and the 1922 Addendum for mandatory membership in a property owners association, a different way to kind of think about it in light of the new HOA laws that changed, and then a few other updates. So the first one is commercial contracts changed, residential contracts changed. They're all here, including the disclosure of relationship with a residential service company that you're all required to use. That form did change, so only use the one with the date of November 8th, 2021. And why is there that date on November 28th, 2021? Well, it was the first time that they have ever had an emergency session that required the law changing and causing the normal process that TREC goes through to approve everything for use by agents. Hello? Somebody needs to be on mute. It's Spooky Monday, right? Okay, so you'll look at the right, if you receive an offer, you better receive it on the 11/8/2021. And why was that? TREC had to use an emergency provision to get it approved by September 1st, because as of September 1st, you could not use the repeal contract form. It's a violation for you to have done so. And we talked about this quite a few months, including up until the time that it was done in September. So again, you can only use the form with 11/8/2021, otherwise it is a violation. Now, what changed in the contract? Well, because the law changes, in paragraph 67, public improvement districts, it used to be a much larger paragraph, but now the law changed where a seller must give the buyer this written notice as required by the property code and use the public improvement district addendum, and it's going to be attached to the contract, and buyer has to sign that prior to the contract execution. Okay, these are all things that have changed and that you were required by law to do now. The next change was in paragraph 7H about residential service companies. It used to be that they were licensed by TREC, no longer. Texas Department of Licensing Regulation is the one who has oversight for licensing the residential service companies. So those were the two big legal changes that happened that caused our forms to change. Now, the next one is paragraph 22, where we attach all the addenda to the contract, right? If you don't have it marked here, it's not going to be a part of the contract unless you attach it with
Marilyn, I don't know about anybody else, but I'm having a hard time trying to follow the meeting when the link that was in the materials for risk management doesn't have what you're showing on the screen. It has 3 other pages.
Right, and I'm just showing you the contract, which y'all are all very familiar with. I'm just bringing it up again for me to point out to where the provisions were changing.
Okay, well, when we're trying to look for something that's not in there, and I totally have missed everything that you've said because I was looking for it.
Well, I gave it in past sessions, so this version has been given before. So if you want to look for that, but again, I'm pointing to a contract form that we gave earlier in earlier sessions, but I'm just bringing it again to the attention of everyone.
Well, can you give me those 3 section numbers, please?
The 6E7 and 7H.
Thank you.
It's on the PowerPoint too.
And the
Okay.
PowerPoint, and the PowerPoint is not there. That's my point. None of that is there. There are 3 pages that are in there. And that's why I'm having a hard time following along. The 3 pages are an addendum for property subject to mandatory membership, an addendum containing notice of obligation to pay improvement district assessment, and how HOA laws are changing. There is no presentation.
Please
And
hit the link.
no reference in the
I put the
contract.
link in the chat 3 times. Please hit the link in the chat. It has all 4 of the things, including the PowerPoint. You can add a PowerPoint to the back agent post. So please hit the link. I just posted it one more time.
Okay, thank you.
My pleasure.
Okay, so we'll get back to the contract showing the various changes. In paragraph 22, you'll notice right above other, they added this addendum containing notice of obligation to pay improvement district assessments. My thing is, I'm really surprised that they made it an addendum to the contract, because our municipal utility districts that are in paragraph 63, they're mandatory the same way. They made these public improvement districts mandatory by law, that a seller must get them and get them signed by any prospective buyer prior to the contract being executed. I'll tell you, there's 2 schools of thought. The broker lawyer committee, of course, is meeting, and they're going to decide if they're going to make now the municipal utility districts, the water district notices, and levy improvement districts, all those different district notices as addenda as well, because HAR is the one who provides us our form, or you can get them at a nominal fee. It's limited by the legislation of $10 from the actual district itself. Again, you don't have to use this addendum. If you get the addendum notice from the district, that can be attached here in paragraph 22 as others. But again, those were the only changes to our contract form. So again, pay attention, listing agents. If you receive an offer, make sure it's 11/8/2021. And if they decide to make a different change on it, we're going to have a new contract to update and use again, instead of just this one. So it's one of those situations they had to use an emergency provision in order to get it done in time for the law change that happened on September 1st. And stay tuned, if we could have the TREC Broker Lawyer Committee and TREC deciding other changes that they might want to consider through the formal process that they're engaged in right now.
Marilyn, I have a question about something you just mentioned. This is Lisa. The lids, because that information is sometimes difficult to get, you said that for a $10 fee, are they required to do it for a $10 fee if you ask, or is it that some will provide it for $10?
In the statute, code statute for all of these municipal utility districts that are subject to this paragraph 63, it states that it should be for a nominal fee not to exceed $10. And they're all required to have it posted on some website. And most of them have their own websites.
Okay, perfect. Yeah, I've gone to their website. Thank you.
Yeah. Now, what does this mean? Again, well, we've been getting lots of contracts that you folks have executed, including commercial contracts. They're subject to the public improvement district as well. And so I'm going to talk about the public improvement districts in a very general way. Everybody, the first place that we were instructed through Texas Realtors and TREC is that you go to the taxing jurisdiction at the appraisal district level. Okay, so you go to the taxing jurisdiction on the appraisal district, and if you don't find it, then it is not subject to it, right? Now, all of these, the public improvement district, the municipal utility districts, they're all called what? They're all called special districts. And the thing about this is a special districts in Harris County. Look at all of them. It's got utility districts, MUDs, water CIDs, all of these various things. They're listed all the time, right? So, but what happens is in a public improvement district, sometimes everybody says, well, how will I know? Should the word improvement be in it? Yeah, it should probably have public improvement district in it. And they happen periodically. We can't say that a new one won't crop up today to be asking for this formation under this statute of law. But again, lots of districts, lots of different names. But if you look at the taxing jurisdiction and you see something that you're concerned with, all you have to do is go to their website, and what is going to look like to you is that you're going to see it was formed under Chapter 372. Again, if it wasn't formed under Chapter 372, it could be 382, but the only 382s are up here in the Hill Country, outside in Bexar County and outside of San Antonio area. So again, it's really an easy way if the sellers don't know this, and they should know it because it's on their tax record, is that you will see that on their website, that taxing entity was formed under Chapter 372. Now you'll notice on this addendum, it's not like our municipal utility district, our water district notices, our living improvement. It doesn't have any numbers, does it? No, it's just got information about giving the name of the district, telling it how it was incorporated either through the city or a county. You have to insert that, seller sign and date it, and then the buyer, again, purchaser acknowledges receipt of this notice before the effective date of a binding contract. And then this form is checked in box in paragraph 22 where it says the addendum regarding containing notice of obligation for public improvement district. Any questions? Okay, as I said, truthfully, most sellers should know if they have it, because why? They're going to be taxed on it. It's going to be, they don't have hidden taxes when you have property taxes. They clearly mark the entity that has taxing authority and jurisdiction over that property. Again, remember, it's that key that you're going to look at for Chapter 372. Okay.
Marilyn?
Uh-huh.
Hi, it's Ty. So is this a form that, you know, just to help the listing agents, would we be able to add it under documents in the MLS listing and then highlight to the buyer's agent that it should be signed prior to an offer?
You can do that. The problem is the seller is required to deliver it, right? And MLS is not a delivery system, you know, for the seller delivering it to the prospective buyer. So just make sure as a listing agent, when you receive an offer, if you don't have one and your property happens to be subject to it, you're going to tell the buyer's agent, please download that form or email it to them and say, until your buyer signs this, my seller will not be able to respond to your offer.
Great, thank you.
Yeah. The punishments about this are vast. As you know, it talks about all sorts of different repercussions. The same way with the one in paragraph 6E3 regarding the water district notice, flood control notice, all those notices requiring drainage and all those flood control type things. The seller is required by law to provide it to the buyer, have the buyer sign it before the execution of the contract. So just remember to pay attention to that, big time listing agents on something like that. A buyer's agent, you know, we review the tax record with our buyers, you know, we go over it. So it's a good time to kind of look at it and say, oh, the property is subject to this. I need to get this notice for you to sign, or I need to get this addendum for you to sign. But again, the key is Chapter 372. Okay, any questions?
Marilyn, I've got one. Isn't all property, residential property, have part of a MUD or improvement that goes with them? So if I understand this, most residential property or all residential property in a neighborhood or a subdivision would be required to have this form as part of any contract.
No, that's not true. It's by property. It's not a general statement. I understand if one development is all in a public improvement district, that it might apply to all those properties in that map area, but it doesn't apply to every property.
Properties that are associated with MUDs.
That's different. Municipal utility districts. There are some that are the property is formed under one, or levy improvement district, but it depends upon the property. It's not blanket like it would be for every property.
Okay.
That's why you have to look at that tax information on something like that. Okay, now we're going to talk about the new HOA provisions. And I provided something to you that is really a great piece for you to send out to anybody you've ever helped with a property that is in a mandatory homeowners association. They say HOA, but they're you can use property owners association. It doesn't apply to condos. Condos are very, very different under the legislature. But in this one, this is a great piece to send to your clients, because really this was a major effort by our association lobbyists to get these changes. They have been working for over 15 years to try and dilute the authority and grab that these HOAs have over property owners. And this time it was amazing, the provisions they had. And you need to let the buyers that you had before, or even sellers who might be interested, they don't look at the law and say, this is the new rights that I have as an owner in one of these mandatory HOAs. And it's real good to bring it out and saying that's why you choose realtors, because you pay for the fees that help do this. And our association is just not about realtors. These are about all property rights for all owners. They don't have to be a license holder to benefit. Our association is incredible about that. And so again, this is a wonderful little piece. This is something you need to send out to your sphere, because they're not going to take the time to find something this summarized about what the laws change. So let's look at them in detail. The fees are capped. The subdivision information is $375. The resale certificates are $75, and then the updated resale certificate is now capped at $75. The other great thing, as of December 1st, TREC has mandated that they will have a central database of Texas HOAs. So instead of having to go all over, it'll be one centralized area for transparency that all owners and agents and prospects that are acquiring property can go to look at all of the fees that are going to be involved, everything. They are required to do it as of December 1st on the TREC website, but if they've already filed prior to December 1st, they have the ability now to delay their filing on the TREC website until June 1st. But all of their websites will have all of this information. But TREC has made it a great place that everybody can kind of go to and see all of the information. And we are going to really enjoy this, because it is supposed to be transparent on all the fees associated that have to be paid in order for the property to transfer. Now, they're also mandated, the HOAs have to mandate maintain their own websites. It's with management certificates, meeting information and notifications on a timely fashion too. Now, HOAs are required to file the dedicatory instruments with the county. These are these certificates that give all of the detail about the fees associated with it and other things. And they're required to do this with the county. So all of them would be subject to that, even the ones that are self-managed. They are all mandated to do that. Then the next one is that property owners have new protections. And this is where, when you send it to your sphere, from time to time, some situations occurred, and maybe during COVID, where the owner of the property may have been subject to a fine or some dispute with the HOA, right? Well, now they cannot provide a negative credit reporting because of a dispute or a fine with HOAs are required to now give a detailed report of charges, right, to the owners and offer a payment plan before reporting delinquencies. So this was really significant as far as what they were made able to do regarding the HOAs and all of their negative credit reporting on any disputes or fines. It prevents some conflicts of interest within an HOA architectural review board. From time to time, we've had some situations. I know when we've had self-managed HOAs, somebody sits on the architectural board and they don't like what this neighbor's wanting to get approved, and it's not fair. So again, some portions of it will assist with the conflicts of interest on those things. The other great thing is it's about time that the HOAs are barred from requiring access to lease agreements. The only thing that landlord, that property owner is required to do is provide the tenant's contact information and the lease beginning date and ending date. It's about time. They're not, they should never have touched that lease agreement. That was a private agreement between the landlord and tenant. The other thing is it benefits the owners of the property. HOAs are now required to solicit any bids for any contract services over $50,000. And we've had situations, unfortunately, where they go to a certain contractor, they don't do bids. Property owners, they have to work in the best interest of the property owners to keep costs down, right? And so this will help them when they're talking about significant bids that are needed for HOA improvements. The other thing is the HOAs are barred from prohibiting certain pool safety enclosures, the installation of certain security measures on an owner's private property, or certain religious displays. Again, their whole goal was to try and minimize the overreach that these HOAs have on property owners. The other thing, they're required to provide members with timely notice about meetings. And they need to be transparent about this. And so the last one is it improves the due process in a dispute resolution, and it provides additional legal avenues when seeking resolution with a dispute with an HOA. Again, wonderful things. It's a nice piece that's pretty easy for you to send to your sphere and let them know what came effective September 1st, and that they need to kind of pay attention to the new regulations that HOAs are subject to at this time.
Hey, Marilyn. Sorry. Marilyn.
Oh, something's going on, right? Okay. So again,
I have a question on this though. Can you explain what the difference is on the resale certificate? A lot of these HOAs have a bunch of different types of certificates, like certificate of compliance. Is that the same thing as a resale certificate, or is that different?
I don't know. Language, we're going to get into language with various HOA areas, but subdivision information, which is defined on our addendum, and TREC has a resale certificate. It does have significant information regarding the capitalization improvements, the cost and everything, but I'm not sure if their language would be synonymous with our resale certificate. But typically when they get the resale certificate, it does say, is this property in compliance? Are there outstanding legal issues involving the owners of the property association?
Okay, I'm just curious where should I go to look to find more information about
Well,
the
you can
different
look at the
certificates?
resale certificate that TREC provides that we have in our forms. And then if you go to one of the subdivision websites, you should be able to find out if it's the same as the resale certificate that is mandated by law, that they have to follow it.
Okay, thank you.
Okay. The thing about this is nobody can believe how sweeping these changes were. And I think that's what you need to kind of let all the people that chose realtors understand. It was your money that helped do this, and your efforts to help all the property owners. Yes.
Philip put his question in the chat. do you see it? It says, are these rules retroactive?
No,
Does the bidding pertain to existing month-by-month services such,
no, if
such
it
as our
exceeds,
landscape contract?
no, it was mandated by law September 1st. If going forward, there is a bid that is $50,000, over $50,000 at the HOA, then it would apply, but not prior to that.
Marilyn?
Yes.
So I had a condo was charging $600 non-refundable application fee for a tenant. Is there a cap on that?
This is not about condominiums. They're
Okay.
different. They're handled differently by
Okay.
law. Yeah. And good luck on that one. I don't know about you, but we never got the straight information on condominium associations. And we really had a difficult time with homeowners associations. For example, an agent would contact them and ask where all the files were, where the subdivision information could be found. And they would say, well, you have to log in and then you have to pay, right? These are the things. When I first started in real estate, the seller, when we took a listing, we got the documents. They were good for a certain length of time, but we got those documents. And so we're going to kind of look now at what we probably want to review in more detail is the addendum for mandatory membership in a property owners association. So what happened on this is that we have a wonderful addendum, and it changed this year, and it has caused havoc. And when I talk about language, a very good question was asked, is this synonymous with a resale certificate, that type of thing? Well, what we have found is it's not this one. Sorry about that. That one comes up because nobody uses the appraisal concerning right to terminate due to lender's appraisal properly. Okay, but this one changed last November and was mandated earlier this year, and it has caused havoc. And the reason for that is some associations are contacting and saying to the title company, here are all the monies that are necessary to transfer this property. And so it describes what it is as far as subdivision information. But paragraph C, we're going to look at that first. This is what has caused so much problem. Fees and deposits for reserve. Well, let me tell you, the title companies, some title companies, it seems like they're making their own judgment call on it. But if you look closer, the HOA that provided all this information to the title company about what they had to collect and these type of things, their language is not using the word what we call prepaids. Prepaids are not a part of this addendum. But what has happened is these associations are now lumping what we would consider prepaids all as reserves. And there's a big difference, because that's why listing agents, you've got to know exactly what it will cost your seller to transfer this property. I mean, all the costs, all the fees, all the reserves, whatever it is. And the reason I say that is because now this paragraph has lumped everything. Remember capitalization and foundation fees and all those things? The seller is now paying them. They're all lumped into this paragraph. They're not separate for the buyer to pay. And we've even had some sellers at closing find out that they're paying prepaids for a buyer. What are prepaids, folks? Well, prepaids are something you'd pay if you were the owner of the property, like property insurance, right? These are prepaids, and these associations say, well, you have to pay 3 months of payments. Well, those are called prepaids. But no, some associations are calling them differently. Some title companies are lumping them all into these fees. And what is so deadly, not so much for buyer's agents, but for sellers, is the buyer's only going to pay this much. Seller's going to pay everything else. So that's why listing agents, you're not going to have your seller accept this offer until you know definitively from the association what are all the fees and reserves for any buyer. Okay, that's what you have to know. And if you're having trouble, which a lot of them are, September 1st was a big day because now they have to be transparent on all of these things. But your seller, that's their property. If they're getting the runaround from the HOA, they need to get on them. They need to get the right information because that would be not part of the abiding by the new law changes, which make everything more transparent to the parties. You know, they blow off agents a lot of times and want you to give a credit card to get information. So again, this paragraph has caused havoc, and it's because things we knew as prepays, which were a buyer's obligation because they're going to be the owner of the property, they're now lumping in. It just depends upon the title companies. Really good title companies don't make the decision. They are deferring to what those documents and the language on those documents from the homeowners association. So again, it's one of those things. This has just caused so much havoc. We've even had an instance which was pretty frightening. The title company made the buyer and seller at closing do an amendment to the contract. I don't know about you, but they cannot practice real estate without a license. And they did so because of the conflict over this. Nobody was going to close. Seller was fit to be tied that those fees were all lumped in. They said, I'm not closing unless we remove those. Well, that's why you tend your closings. That's why you look at the closure statements very closely on all these. That's why you know what's coming, because you don't want your seller to be at the closing table and be hit with something and saying, as he did last week. When I bought this property 3 years ago, I was the buyer and I had to pay this foundation fee. And now you're telling me I have to pay it for this buyer. Yes, seller had to pay all but $150. The buyer was only paying $150. So again, be very, very careful about this. Listing agent, it poses much more of a situation for you than it does for a buyer's agent. There's only a couple of things I'll point out as a buyer's agent. Most of the time we see A4 negotiated, right? A1, buyers have a right to terminate. A2, buyers have a right to terminate. Buyer A3, only if the seller fails to deliver within the 10 days, a buyer has the right to terminate. But when they do A4, buyer can't terminate for any of this. So buyer's agents, here's what you're going to have to do. You're going to have to make sure that if your buyer has chosen A4, they need to read all of the bylaws, the restrictions, and everything concerning this property during their termination option, because they won't have an ability to terminate if it's something is revealed that they just can't live with. So make sure you put that in writing on something like that. Now,
Marilyn,
yes.
on this, does the subdivision, and this has just come up recently, you're saying get them to read it during the termination period. Is the new law requiring this to be posted to where people can read this, or do they have to get it from the seller? My property manager is saying that sellers are required by law to provide all documentations regarding deed restrictions and covenants to a potential buyer.
Well, a property manager?
Yes, it's coming straight from his mouth to me.
Okay, well, if this addendum is on the contract, the parties negotiate this. There's nothing else in the contract that says that the seller is required to do it unless they make an agreement in paragraph A. Now, what I am going to tell you is that's exactly what that law did. It says all of these documents will be posted on those websites.
Great.
And
Okay.
so, yeah. And so Trek will have their website December 1st. But again, if this HOA filed it in October, they don't have to file it at Trek until June of 2022. So you'd look at their websites.
Okay. And then the second thing they did is, I guess they changed our transfer fees, where 6 months ago, our transfer fee was $250 and now it is $533. So they
I'm
got
sure-
away with changing the resale certificate amount by putting it into a transfer fee. That's what
Well-
it appears to me.
Well, as of September 1st, they're capped at those fees for subdivision information and resale certificates and that. Transfer fees are not there. They just have to be transparent. In other words, they have to be where all parties can go to any HOA's website and see what is involved with the transfer of the property.
Great. Thank you so much.
You're welcome. I'm really hopeful that it will make it more transparent, but easier for the parties to get this information. We have listing agents who beat themselves up trying to get all of this so that the seller will make an informed decision when they receive an offer. And most sellers say, well, I just want to go under contract. Oh, but when the day of closing comes and they're paying this outrageous fee, then there's a whole different matter, which we all know how people are. At the time, they're not focused on what the reality might be when they come to close and fund.
Marilyn,
Uh-huh.
I just wanted to point out that this form for the HOA, a lot of agents put it in MLS as an attachment with number 4 already checked in attachments, like they're attaching the seller's disclosure. And I always disregard what they have under attachment because it should be something negotiable. It should not be something that the listing agent tell me that I have to take number 4 because they have it in attachment.
And you're doing the right thing, Dilsey. Listing agents who provide this form are in violation of track. We don't use forms until and does the buyer present an offer on the property? Oh, yes, the buyer does. So you're doing the right thing. I can't make, listing agents do things all the time that are not right, but do the fiduciary duty to your buyer. You can say, they're trying to make us say that we don't get to negotiate, and that's not true, buyers.
Yeah.
You have the right to negotiate. This is your offer to the seller. So again, it is unfortunate when we see parties misuse them at the wrong time, which is a violation of track. I'm going to tell you what did hang up a listing agent. A listing agent and a buyer agent were going back and forth, and they talked way too much. They were negotiating terms of this offer verbally on a lot of things. And the listing agent had their seller sign this. Posted it in MLS, signed. Buyer agent downloaded it. Well, when the buyer thought they had a contract and the seller said, no, we don't have a contract, they got an attorney involved. And the attorney saw that his seller's signature was on this document and said, oh, the seller did agree to the contract because otherwise, why would the seller have signed it? Very deadly for the listing agent that thought they were being very efficient in helping their sellers. That was a horrible one to extricate it, themselves from. And I don't know about you, but to tell a seller, well, I did something and now you have to pay for legal fees, and it just doesn't work out very well. Lawyers are very important, but it doesn't take a law degree to be a license holder. It just takes understanding the use of the forms, the proper use of the forms, and the proper timing that's involved with the contract forms. And it's not diminishing what we do by any means. Anybody who knows me knows that our compensation isn't even close to what we do in every transaction, truthfully. The amount of time and effort that we spend. And a lot of times we have sleepless nights when parties are in a dispute or something's kind of hanging over our heads and we need to get it resolved so that everybody rests better. We always have a high fiduciary duty to our buyers. So Dilsey, you're right. Please don't use whatever the listing agent provided. The buyer has the right to negotiate with the seller. Now,
Hey, Marilyn,
uh-huh.
I have a question. I've moved away so I don't get any feedback.
Okay.
You mentioned that the HOAs can charge 3 months of property insurance, private insurance.
No, they're prepaids. They're HOA fees.
Just the HOA fees, not the private insurance, house insurance.
No, but I
Okay.
said prepaids are like homeowners insurance. That's a cost of the owner. Same way prepaids. They're asking them to pay 3 months of fees up front, right? Well, those are an owner's expense, which is the buyer.
Right.
Yeah.
Okay.
And so I'm just trying to help people with prepaids and reserves. We absolutely understand what prepaids are. These HOAs are just lumping everything into this other realm, and that is causing problems for our sellers in particular when it comes to closing. Okay.
Marilyn,
Mhm.
so are these 3 months paid in advance will be credited to the new buyer? Or
Well,
the new
it-
buyer will have to pay also those 3 months?
See, I don't know. It really depends upon how that HOA language, but I know for a fact that if the buyer is needing to know what all their expenditures would be, you would need to know all this information as a buyer's agent. You would need to know what is the involved in all the fees and deposits for reserves per this HOA, because you'd have to help the lender's going to know this too. The lender knows that they have to have reserves and they put them on the closing statement. The problem is, which side did they put them on? Do they put them on the seller side because of this addendum that's at $100? So again, this element alone in our transaction, if it's not done well, we're all going to be in trouble. Do you know what I'm saying? And so I know everybody thinks, well, why are you spending so much time on this? Are you kidding? This is probably one of the most misused forms by realtors and agents, either coming from the other side or even on our side of it, right? So again, I wanted to point out some of these elements. Now, here's what happens. A4, which is the majority of the time we see now that it's marked, right? That means that the buyer does not require any of the subdivision information. Well, guess what? Somebody else might, and it's in paragraph D. So, seller authorizes the association to release and provide the information and any updated resale certificate if requested by the buyer, the title company, or any broker to this sale. Okay, so seller is given permission, but if buyer does not require the subdivision information or an updated resale certificate, which is smack dab on A4, right? And the title company requires the information from the association, such as status of dues, special assessments, violation of covenants and restrictions, and a waiver of any right of first refusal. Sellers always negotiate that the buyer will pay the title company. Okay. Well, I don't know about you, but if I was a buyer's agent and my buyer decided to do this, the moment they decide to waive their termination option, they better give that money to the title company, because the title company will not acquire those documents. And the buyer could be held in default of the contract if they don't close by the closing date. We've had so many not pay the title company, and it's not the title company's job. I had one person who was just lambasting title companies about not doing their job. Excuse me, it's the realtors involved. If you're a listing agent, you're going to stay on top of this. If you're a seller, mark that box, or a buyer's agent. No ifs, ands, or buts. Now, what could be the problem with the title company is if the buyer did pay it, right? And then the title company failed to order it. Well, that's a different scenario, but not the scenario where the party who marked that box has a duty to pay the title company to obtain everything that the title company is going to need in order to close the transaction. Does everybody understand D? Everybody understand? Pardon me?
Hey, Marilyn.
Uh-huh.
Okay, I have a question. Okay, so I have a seller that's getting ready to put a property on the market, and I was going to advise them to get the HOA, all the documents prior. The HOA to me they play God, where they take forever to get back with you or get the documents, and they can actually hold up a closing. So wouldn't it be better to get all the documents prior to selling the property, and having that? And also, whoever buys the property, they can also acquire that later.
Yeah, but later is not too good for us if we're a realtor representing their best interest, okay? Just saying, to get something after it closes and funds, not very good. But that's why I'm gonna get to number 3, A3, because here's the provision that we have. I'm gonna give you a scenario. And as I said, when I first became licensed listing agents, we got all this. We were ready to deliver it, because it takes 10 days, business days, for an HOA to even respond to a request. And there was all this type thing. But let me talk about buyer, what buyer has said to the seller and what a seller could certainly negotiate. It says buyer has received and approved the subdivision information before signing the contract. This is a seller who went out there, got all of them, and has them ready to go. Okay. So now buyer and seller are negotiating paragraph A3. And the seller is going to say, buyer does not require an updated resale certificate. That takes away all of the termination provisions that a buyer may have, right? In the event that the title company says, oh, wait, we do require an updated resale certificate. When the seller negotiates with them, they've marked the box buyer. And the cost is only going to be $75 for an updated resale certificate. That's capped. So let me tell you, a lot of agents don't use paragraph 3, and that's why I'm doing this, is because of this transparency, the availability of all these dedicatory instruments and management certificates that they're now forced to file and place on websites. It might be well for a seller to do, especially in this market where these properties are moving quite fast. That's the whole element of all of this. The other thing is I had to walk an agent through using this form, because they had a seller on the first contract that they were under contract. The seller authorized what? D, that they would pay for it. Paid the money, got the documents, and then lo and behold, the property didn't appraise very close to closing, and the buyer had a provision to terminate, right? So now the seller's got them. And I said, this is when you use A3. Give them, deliver them to the buyer before the contract is executed. Buyer will mark that they don't require an updated certificate, so that there's not that element of the seller getting the payment from the buyer and then going and ordering and all that kind of jazz. And again, D, it will be marked for the buyer. If the title company needs an updated resale certificate or anything else, buyer's got to pay for it. Very different scenario here. Okay. And as I said, this has changed quite a bit because of the law that changed September 1st. And they have played games with owners of properties and realtors involved in the transactions for far too long. We've been involved in several ugly lawsuits where the information we were provided by the association on one day wasn't the same 2 days later for confirmation, and then wound up not being true after the property closed and funded. So again, this is a very interesting addendum, but you have to understand it's got different types of options for the parties to agree to. My concern for you as agents is when your client has agreed to authorize getting the documents that it might be necessary for the title company to close the transaction, or the lender might require that, you just better stay on it based upon whoever is marked in this box, either a buyer agent or a listing agent, and making sure that part is confirmed, that they made the payment. And in the event the title company drops the ball, that's a pretty sad thing, but that would be a dispute between the party who paid it well in advance of the closing date, and then the title company dropped the ball. Very different scenario that we have. Any questions?
Marilyn, I'm still a little confused. So when on A subdivision information, it says it means a current copy of the restrictions applying to the subdivision and bylaws and a resale certificate, all of which are described by the property code. Are you saying that that is now capped at 375?
Based off of what the HOA laws changed, that they said it was. And if there's an updated resale certificate, or say the subdivision information that you're providing doesn't have the resale certificate, you know, might have the subdivision information, there's the cost for the resale certificate. But subdivision information is defined.
So is subdivision information, it's a copy of the restrictions as well as any financial information on the subdivision, correct?
Resale certificate.
Got it. Thank you.
So again, as I said, this is a very important addendum. And you need to take the time to understand which part will apply best. Prepare yourselves, prepare your sellers for it, make sure that all parties understand it. But more importantly, I'm going to really look forward to this transparency that is supposed to be by law that the HOAs will now have.
Marilyn, one more question about the fees. Does the new law also talk about the reserves, and are those going to be disclosed per HOA?
Correct. You're supposed to be transparent on all the fees that are associated with the transfer of the property. How the parties negotiate who pays what, that's in the contract and the addendum.
So to be clear, that transfer fee is something that's separate. As long as it's disclosed, then the HOA is pretty much compliant, right? As long as they disclose what the transfer fee is.
All the fees associated with transfer. It's just not called a transfer fee. It's all the fees, all the reserves associated with it. Because if you look at this addendum, there's a key word in here, and it says that in paragraph C, and other charges associated with the transfer of the property. That's how those capitalization fees come in. That's how those foundation fees, they're getting them.
Right. Yep. I'm glad you said that, because cap fees were one of the things I was wondering about too.
I know, and they're there. It's right there in that paragraph. And so a poor seller who said, I'll pay everything other than 150, they were quite shocked when it came to their closing statement. And I don't know about you, but I've been at a lot of closing tables. You don't want this kind of dispute to come up, either for the party you represent or even for the other side. It does not bode well for either buyer or seller under something like that. So it takes a little bit more time for y'all to get this right, meaning making sure you got it, and that a seller would never agree to something until they have the full impact on the estimated net sheet, all those fees and reserves and other charges that are associated with transfer of the property. Okay. Next, I'm going to tell you a few other things that happen per the law. Appraisers are now allowed to conduct an evaluation without complying with the USPAP in certain situations. Those are uniform standards of practice that appraisers have to follow, right? And the reason for that, during COVID, we had a lot of suspension of those, the waiver of it. Remember how we had that waiver that really good, well-asseted buyers, lenders waived the appraisal. So now they're able to conduct this evaluation. It's not the same as the big full-blown appraisal, but there will be, under certain circumstances, that a lender would go, you know, we don't need the full-blown thing. We just want an evaluation. And why are we doing that? Why do you think they did that? Because we're having more appraisals not come in, and the parties are in dispute about even extending the closing date. We have just got a horrible situation. And you know what's what's sad too is many times if those appraisals aren't picked up on a timely basis by the appraisal management company, somebody's got to be paying attention to that, because that does have a direct impact on the closing date, right? And getting all the documents ready, because paragraph 2B of third party is clear now, and it's not for FHA or VA, but other financing. It says that 3 days prior to the closing date, if you don't have the appraisal in hand, you are in trouble as a buyer, period. And we've had more buyers who said, well, it's not my fault. Oh, but it's your contract. It's not the realtor's fault. They always try and like, we have nothing to do with that. That is something that comes back to the appraisal being done in a timely fashion. But again, we've had some issues with surveys. There's only so many surveyors that can get out there and do the work the same way with appraisals. Now, I'm going to tell you, if you have a cash contract, buyers have to be told by you that while you're not contingent with the lender, you need to get your appraisal during the termination option. And believe it or not, I think appraisers move a lot faster when it's cash and it's not subject to lender financing, because we haven't had too many problems with cash buyers being able to get their appraisals done in a very timely fashion. The next one is, I can remember this vividly. Do you remember trying to figure out if we were essential business or not? Oh yeah, well, I always knew we were, but they didn't ask me. No, they didn't. What happened was we had cities and counties involved in it. And finally, the governor had to come out and say, hey, we were essential, which we always knew we were. But now it's codified, it's in law, and the cities and counties cannot limit residential and commercial real estate activities or real estate support services. What are those real estate support services? Title companies, surveyors, appraisers, inspectors, right? During a state of emergency. So we're not going to have to worry about this. And I even hate to think that we're going to have another state of emergency, but in the event there is one, we now know it's in the code of law that we are an essential service, as well as all the auxiliary real estate support services too. Now, the next one's kind of interesting. We've had some disputes over the years. We've had sellers who bought a property 3 years ago from a very large builder. There was a 10-year warranty on the air conditioning system. And when the new buyer tried to file a claim for a warranty, they were told, no, you didn't transfer the warranty and pay this fee and this. And who do you think they blame? The buyer's agent. So I'm going to show you something. This is about air conditioning systems, but I'm going to show you something very quickly in the contract that you all know very well, because everybody knows the contracts by heart. But in paragraph 7, which is very important, which is the property, and that's the reason we know that paragraph by heart, because it's so important. But in paragraph 7D, 7F, they negotiate, right? This is where the seller is told, if you're going to make a repair, you have to do it by somebody who's licensed, if there are licenses required by law, or that are commercially engaged. For buyer's agents, when this type of work is being done, it is a buyer's expense to get any transferable warranties with respect to these repairs, right? So buyer's agents, make sure that you've covered this with buyers. I bring it up because warranties from time to time, and those transferable ones, have come into play in our disputes. But what I am going to tell you about that's not covered here is where a seller says, yes, I had foundation work, or yes, I had roof work, and I have a transferable warranty. Sometimes on these foundations, they said what? Lifetime transferable warranties. Buyer's agents, be very careful. During the termination, you better have the buyers verify what's the process for transferring that warranty, how much is it going to cost. The reason I say that is we've had too many buyers, after it closed and funded, found out that the lifetime transferable warranty that was put in MLS, that was put in the seller's disclosure, doesn't exist. the company is no longer in business, buyer failed to transfer within the number of days that is required by the company, and all these different things. So warranties come up from time to time in our scenarios. So just buyer's agents, make sure you pay attention. And I'm going to tell you, listing agent, if your seller says there's a transferable warranty, I'm thinking you're going to say, really? Let's find out. You're going to verify that that company is still in business and all what's involved in the transfer of it, because buyer's agents are going to call you with that kind of information. So your seller needs to understand it. We had a horrible lawsuit. Seller said transferable warranty, very expensive, experienced listing agent. Never thought anything about it. Buyer moves in. What do you think they have? Foundation problems. Turned out the buyer didn't transfer the warranty because, oh, by the way, the company was no longer in business. So the agents were involved in that resolution, and that's not where you want to be. You want to be recommending the best practices for them to follow regarding any transferable warranties and fees and that. But now air conditioning companies, if your air conditioning system is warranted by the manufacturer, they don't have to pay any forms. They have no fees they have to pay, which is a great thing, truthfully, because we have a lot of transactions where people have acquired new homes and they turn around in a few years, need to sell them, right? And there are wonderful warranties sometimes with some of these homes that are sold new today. Now, the next one is coming as of January 1st. Okay, we're going to get it more into this in December because we want to make sure everybody understands it. But now landlords are required as of January 1, 2022, they have to give notice to prospective residential tenant at or before execution of the lease of whether they are aware that the rental dwelling is located in a 100-year floodplain or whether the rental dwelling has flooded at least once in the last 5 years. Now, I don't know about you, but if I was a landlord, I would tell them, even if it flooded 10 years ago, I would be forthright and coming. I am going to tell you, I am on the Texas Realtors special task force, and we are looking at changing a lot of our forms, not the contract forms, because we promulgate those from TREC and we approve them as Texas Realtors. But we're going to be changing the lease. What does this mean for listing agents? Well, you better know this, because in the rental tenant criteria that a prospective applicant signs before they make application, it's going to be probably at the top of the banner on it. So again, we're going to have a lot of issues that are going to come up with our forms changing from Texas Realtors. Again, they do all the commercial forms, they do all of our private agreements with listing and residential, our tenant agreements and those type of things. So again, this is really big because landlords are now required by law. And if they don't tell the tenant and something happens, oh, it's not fun at all on something like that. So again, we will be going through that regarding those situations, because again, it happens from time to time, and we, are subject to sometimes listing agents. It's a very unique transaction, and if you haven't done them a lot, you might not pay attention to them as closely. These transactions for leases are very risk laden. They really are. The landlords themselves, but a lot of times they contact a listing agent and they're expecting you to be the landlord to know everything about that. So we'll talk about that when it comes to around December. That should be something that will jog your memory and be prepared if you are listing a property right now that is for lease and it doesn't have a tenant prospect in it. Any questions? Okay. You want to know what we're going to do next month? Well, we're going to have our mandatory risk management meeting on October 25th, on Monday, October 25th. And during that time, the brokers are mandated to do these events under the broker's responsibility rules. So what will be coming to you will be a lot of information in preparation for the meeting. And then during the meeting that will be covered. And it's your whole team. It's Hubert and Mitch, myself, and Larry and all of us, and our insurance broker, Henry Font, will be available to conduct the training on that day. So again, stay tuned for something like that. In November, we're going to probably have to be prepared, whatever truck's going to do to us. And I should have an update about the actual forms that Texas Realtors is looking at changing. The Department of Justice dropped their settlement agreement with us. And so we're taking it from the perspective of all those things the DOJ tried to get NAR to agree to on a settlement. We're going to incorporate those into our documents. We're going to be very well prepared, as most of our documents really complied with it. The biggest thing, again, no buyer agent ever gets to say their services are free. Just make sure you pay attention to that. If you need your code of ethics training, you better pay attention. You know, it's that 3-year cycle. And those are all things that you don't want that to lapse and not have your membership in good standing with the association. So pay attention to those. And we will keep you posted and look forward to seeing you on at the risk management meeting. Everybody take care.
Bye, Marilyn. Thank you.
You're welcome. Stay safe,
Thank you,
everybody.
Marilyn.
Thank you.